Assalamualaikum and hi, this is Group 3. We are analyzing cases about vicarious liability.
Hi, my name is Anissa binti Abraza A214120. I am analysing the case of GMP Kaisar Securities India Berhad against Muhammad Amir. So the fact of the case is the GMP Kaisar Securities India Berhad employed Jaafar as a personal bodyguard and also equipped Jaafar with a firearm. So Jaafar was assigned to protect Datuk Ong Teh Kwang, which is known as Datuk M, under a contract between GMP and also North Metal Industrial India Berhad. So on the 1st December 2016, while on duty in a car with Datuk M, Jaafar shot and killed Datuk M and went on to shoot randomly at the members of the public. So the respondent, known as Amirul, he was injured when he approached the scene to inquire about the incident. So Amirul suffered grievous injuries and later filed a claim for damages against Jaafar and also the GMP's Kaisar Securities in Berhad. So the High Court held that GMP vicariously liable for Jaafar's action. So this decision was affirmed by the majority in the Court of Appeal but contested by the minority. So the issue is whether the GMP could be held vicariously liable for Jaafar's wrongful and criminal acts, and also whether the failure to specifically identify the tortious act committed by Jaafar negated to vicarious liability. In this case, the legal principle include the wrongful or tortious act. Jaafar's act of discharging a firearm at Amirul caused a grievous physical and psychological harm. While the act was a criminal offence, it also amounted to a tortious wrong, such as like assault and also battery. So the court held that even if no specific tort was liable, the wrongful act inherently attracted the liability under the tort of the law. The second one is the special relationship recognised by the law between the person alleged to be vicariously liable and the tortfeasor. So the GMP Kaisar Security employed Jaafar under a formal contract, established an employer-employee relationship. So this relationship included authority, control, and also responsibility over Jaafar's action while performing his duty as a bodyguard. Last but not least is the tort committed within the course of employment or sufficiently closely connected. So the federal court applied the close connection test to determine that Jaafar's action was sufficiently connected to his role as a bodyguard. So Jaafar was armed and tasked with protecting his client Datuk Ong, also known as Datuk M, using a firearm provided by the GMP. Although Jaafar's actions were unauthorized, his use of the firearm occurred while carrying out his assigned duty. So the nature of GMP's business is to providing armed security services, inherently created a risk that manifested in Jaafar's wrongful action. So the court concluded it was fair and just to hold GMP vicarious liable because the wrongful act was not independent of Jaafar's employment duties. So the arbiter dicta in this case includes the first one is the close connection test must be fact specific. So the court emphasized that the close connection test must be applied based on the specific facts of each case and cannot be used as a one-size-fits-all rule. So the second one is the policy of vicarious liability. The employees can be held liable if their business created risks that lead to wrongful acts, even if the acts intentional or a criminal. Next is the comparison with the precedent cases. So the court referred to the cases like Bernard and Howell to show how different outcomes depend on whether the employees' actions are closely connected to their job duties. The last but not least is the risk created by the employment. So the court highlighted that employers who create risk through their operation should be held responsible when those risks result in harm. So in this case, the federal court held that GMP Kaisar Security was vicariously liable because Jaafar's wrongful use of a firearm was closely connected to his employment duties as a bodyguard. The firearm provided by the GMP for Jaafar's role duty created the risk of harm that led to Amirul's injuries. It was fair and just to hold GMP liable since Jaafar's actions were not independent on his employment duties but arose directly from the risk associated with his role. So based on the case, the High Court found that GMP Kaisar Securities India Berhad vicariously liable for the grievous injuries suffered by the plaintiff, which is Muhammad Amir, which caused by their employee Jaafar. So the court held that Jaafar's wrongful actions were sufficiently connected to his employment as a bodyguard equipped with a firearm by GMP. So the High Court awarded 70,000 ringgit in general damages and also 14,470 ringgit in special damages to the plaintiff.
Hi, so I'm going to talk about the case of Ahmad Iqwan bin Ahmad Fauzi against Muhammad Fahmi bin Endut. So the facts of the case is in 2015, 5 students of Sekolah Menengah Sultan Mahmud, Kuala Terengganu, has repeatedly assaulted an appellant, which have resulted to the injuries of his right ear. So the father has made a lodge a report police. The issue of this case is whether the school authorities and the government of Malaysia were vicariously liable upon the assaulted and whether the assault was reasonably foreseeable event, thus imposing the duty of care towards the school authorities. Legal principles that I applied in this case, the first one is wrongful or tortious act, which can be seen when the 5 students who assaulted the appellant and resulted in the injuries. And second one is a special relationship that is recognized by law between the person alleged to be vicariously liable and the top officer, which can be seen in the government of Malaysia has a special relationship with the school authorities because the school authorities is the employee of the government of Malaysia. So the third one is the tort is committed within the course of employment. So when the assault happens, the school authorities have the duty of care to prevent the bully. So the next one is the ratio decidendi. I will tell two of it only. So the vicarious liability of the school authorities and the government. School authorities will help vicariously liable because the assault occurred within the school premises and within the time when the students was under their supervisions. So the second one is the assault, which the defendant will help liable for assault as there was sufficient evidence that show that the assault happened. The obiter dicta of this case is the role of school as safe havens. The school must be a safe place for students to study, not to learn, not to bully others. And the second one is the bullying in school, which happened many times before, which it is unfortunate events for all students. So the federal court decision, they set aside the court of appeal decision and reinstated the decision of the high court, which because there was sufficient evidence to prove the assault happened, and the school authorities were vicariously liable as the assault happened within their supervision.
The case that I'm discussing is Jasni bin Yub, Mawakili Diri Harta Pusaka Yub Pindaru Simati and others, and Sandstone Soil Sendirian Berhad 2024. So the issue of this case is whether the ninth defendant, who is a partner in the legal firm with the fourth defendant, is vicariously liable for the misconduct in facilitating fraudulent transactions and breaching her fiduciary duties. So in this case, the fourth defendant, who is a solicitor in the legal firm, where the ninth defendant is a partner. So the defendant prepared and executed the sale and purchase agreements for the plaintiff based on forged vesting orders provided by the first and third defendants. So the plaintiff argued that the fourth defendant conspired with the first and third defendants by failing to verify the authenticity of the documents and failed to protect the plaintiff interest. So the plaintiff sought to hold the ninth defendant vicariously liable for the fourth defendant's misconduct under Section 12 of Partnership Act 1961. So the ratio decidendi of this case is that the first to third defendants fraudulently obtain vesting orders by using forged documents, and the fraud nullifies all subsequent transaction, making the sale and purchase agreement void. And the fourth defendants, as the plaintiff solicitor, breached her fiduciary duty by failing to protect the plaintiff interest and conspired with the first and third defendants. And the ninth defendant, who is a partner to the fourth defendant, was vicariously liable for the misconduct of the fourth defendant. There's the legal principle, which is the Partnership Act 1961 under Section 12, and the case law used To Fong Cheng and Pang Chong Kiat 2020. So the partners are vicariously liable for the actions of their co-partners if the acts were within the ordinary course of business, even if the misconduct was unauthorized. The next one is Dubai Alumni Co. Limited versus Salam. So the liability arises where the act was closely connected to the partnership business, making it fair and just to hold the firm liable. So the obiter dicta is that the partners in legal firm must establish mechanism in order to monitor and prevent unethical practice by their co-partners. The second one is that the court emphasized that clients place trust in legal professionals and partnerships must uphold this trust through diligent oversight and compliance with professional standards. The court held that the fourth defendant was definitely liable for fraud and breach of the fiduciary duty, and the ninth defendant, who is a partner to the fourth defendant, was vicariously liable under Section 12 of the Partnership Act 1961. So both fourth and ninth defendant were liable to pay damages of 976,062 ringgit 30 cents to the plaintiff.
Assalamualaikum and hi, my name is Muhammad Khairul Imran Bihami, matrix number 814129. I'm analysing the case of Singkong Logistics Sdn Berhad against Project Lebuh Raya Usaha Sama Berhad. The fact of this case is when the plaintiff, Project Lebuh Raya Usaha Sama Berhad, sued the defendant, Singkong Logistics Sdn Berhad, under the tort of vicarious liability for unpaid tolls. The claim was for 580,369 ringgit 27 cents, covering 5,390 toll violations committed by 90 lorries that were registered by under the name of the defendant. A documentary evidence known as PV form containing the crucial information such as the date, the time, place of incident, as well as the registration number of the vehicle and the amount of unpaid tolls was filled up by the toll operators. A total amount of 570 witnesses was supposed to be called to testify before the court, but only 122 witnesses were called, and the defendant argued that tolls were the responsibility of the lorry drivers, and the company reimbursed drivers based on the receipts. And the legal issue for this case is whether the defendant was vicariously liable for the unpaid tolls committed by its employees during the course of their employment, and whether the PV form used to record toll violations were admissible under the Section 73A of the Evidence Act 1950 without calling all the witnesses to testify. And the legal principle for this case is the first one is special relationship recognized by law. This special relationship existed between Singkung Logistics, the employer, and the lorry drivers, the employees, as the lorry drivers were under the employment and direction of Singkung Logistics. And the second one is tort committed within the course of employment or is sufficiently closely connected. The toll evasions occurred during the driver's course of employment, as the trips directly benefited Singkung Logistics by facilitating its business operations, and the actions of the drivers were sufficiently closely connected to their employment to justify the imposition of vicarious liability on the employer. And the ratio descendandi, the first one is vicarious liability. The court affirmed that an employer is vicariously liable for wrongful acts committed by employees in the course of employment, provided the acts are connected to the employee's duties. And the second one is admissibility of PV forms. Section 73A, subsection 2 of the Evidence Act 1950 allows primary documents to be admitted without calling the makers if doing so would prevent undue delay or expense. For the obiter dicta, the court noted that rejecting the defendant's request to call all 570 witnesses didn't breach natural justice, as the testimony would have been repetitive. This decision ensures procedural efficiency while maintaining fairness. And the court decision for this case is the High Court dismissed the defendant appeals, holding them vicariously liable for the unpaid tolls, and the claims were awarded to the plaintiff.
Assalamualaikum. Today I'll be talking about the case of Azrul Ashraf Abdul Hadi, Azrul Shakir Zahir Rashid and others. Of the case. A road accident occurred between the motorcycle ridden by the plaintiff and the military jeep driven by the first defendant, a military officer who worked with the Malaysian Army, the second defendant, and was employed by the Ministry of Defence Malaysia, third defendant, and the Government of Malaysia, the fourth defendant. The plaintiff claimed that the accident was caused by the first defendant negligence when the military jeep unexpectedly turned right into the plaintiff's path without signalling or stopping, leading to a collision with the plaintiff's motorcycle. The defendant, on the other hand, argued that the plaintiff had contributed to the collision by speeding and riding recklessly in the rain without paying attention to the surrounding issue. Whether the government, second to fourth defendant, can be held vicariously liable for the negligent act of the military officer, the first defendant, while he was on duty. Ratio descendandi. An employer can be held vicariously liable for the negligent acts of the employee if the wrongful act occurs within the course of the employee's employment. In this case, the court held that the government, second to fourth defendants, were vicariously liable for the negligence of the first defendant, as all the elements of vicarious liability were fulfilled. The court also relied on Section 5 and 6 of the Government Proceeding Acts 1956, which implied that the government can be liable for the wrongful act of its employees performed during their employment. The legal principle. Vicarious liability is when an employer or principal is held responsible for the negligent acts or omission of the employees or agents, provided these actions occur within the scope of employment or official duties. According to the case of Tang Eng Siu and Ano and Dr. Jajit Singh Sidhu and Nader, there are three conditions to establish vicarious liability, namely, there must be a wrongful or tortious act, there exists a special relationship that is recognized by law between the person alleged to be vicariously liable and the officer, and lastly, the tort committed within the course of employment. The obiter dicta in this case is that general traffic rules. The idea of right of way and the duty of drivers, especially those handling heavy vehicles, to exercise extra caution is here underlined by the court. This, however, does not have much importance in regard to the specific facts of this case, but instead gives a wiser statement about good driving principle. Court held that the first defendant was 80% liable for the accident due to negligence. The court found that the defendant failed to yield the right of way to the plaintiff who was travelling on a straight road. The plaintiff was assigned 20% contributory negligence for excessive speed and failure to exercise caution under wet and slightly dark road condition.